Hello, everyone. Thank you for joining us this afternoon for yet another webinar. Uh, I'm your moderator, Vishal Sharma. Today, I'm joined by alongside Prashanthi Reddy. Prashanthi is an alumni with the University of Pennsylvania Law School. She has been in the field of immigration since 1997, admitted to the bar in New York. She is a member of the American Immigration Lawyers Association, as well as the New York Bar Association. She's currently immigration chair for the National South Asian Bar Association and immigration co-chair for the Federation of Indian Associations, and currently actively involved in pro bono legal work as well. We'll start the presentation with immigration updates. Prashanthi, over to you.
Hello, everyone. Thank you for joining. We hope more of you will join as time passes, but we want to be on time. So let's start the presentation. Today, what we're going to do is discuss briefly about the visa bulletin to start off with, and then we'll get into an analysis of a few common RFEs, and that'll help. That's very important actually, because it'll help you then if you do get an RFE, it'll help you it'll make you better prepared to respond to those RFEs. Also, it will tell you what to avoid when you're filing your H1 and how to avoid those issues. It's always better to get a H1 without getting an RFE, because then the processing time is much less. The chances of denial are less. Once you get an RFE, the chances of denial go up. So keeping all that in mind, we thought we'll have a presentation today about a few common RFEs and actually live examples of those RFEs, and as I said, how to respond to those RFEs. And for those of you who've never seen what a request for further evidence looks like from USCIS, today is the day. You will be able to see what one actually looks like, how to read an RFE, how to go between the lines to see what they're actually asking for. It's not always apparent with reference to what they're asking for. Sometimes it's clear. Sometimes, you have to know enough of the law to know what documents to submit. It's not always straightforward. So we'll discuss a few of those things today. Let's go to the first slide.
Sure.
So as I was saying, that we need to discuss the July visa bulletin. This is a hot news. It's just out. So it merits discussion, and also we have a lot of good news with reference to the July visa bulletin, and unexpected good news. And let's see why. First thing is that the USCIS, we're only going to be talking about employment-based cases. The visa bulletin for July will only accept the final action dates. They will not accept the table for dates for filing. As you know, in a visa bulletin, there are two tables: dates for filing and final action date. Usually in the beginning of the year, they allow you to file your application based on the dates for filing table. And the dates for filing table, usually the dates are more advanced when compared to the final action date table. That's because, in the dates for filing table, they're allowing you to file your 485 in advance, in anticipation that by the time your 485 is processed, your priority date will become current. So they're allowing advance filings, and so those dates usually look good. But in this visa bulletin, as we go through the year, remember the fiscal year ends in September. So as we go through the year, we will see that the USCIS will no longer look at the dates for filing table. They'll look at the final action date table, because they're not anticipating any, big forward movements in the priority dates. So that's one thing. They're looking at the final action date in July. This is the middle of the year, almost towards the end of the year, if you look at September as the end. So they are looking at the final action date table. For EB3 categories, they've given us an alert that due to the high demand in EB3 category, there may be retrogression as early as next month. This is not unexpected, as again, as we go through the months in the year, for the fiscal year, we will see that there's less and less forward movement, and because it's towards the end of the year and all the numbers are being used up, so we see less to no forward movement as we go progress in the months. But there is a surprise for us in the month of July. Next slide. We see significant forward movement in the month of July. I guess they had to use up all the visa numbers towards the end, which is what they're doing. So India advances by 11 months for EB1 category. So now it's February 1, 2022. China is advanced not that significantly, only by 2 months, and all other countries remain current. For employment-based category 2, India advances by 2 months to June 15, 2012. China by 1 month, and all other categories advance by 2 months. So if you see this EB2 category in general, they've advanced by 1 or 2 months. Not a significant advance, but still something is better than no forward movement and definitely better than retrogression. There's no backward movement. EB3 advances minimally by 1 month to September 2012 for India. For China, there's no forward movement at all. And all other countries, EB3 has retrogressed by 11 months and 3 weeks. So you see a retrogression already for EB3. You can expect further retrogression next month. EB5 has not changed at all from last month, so it's status quo, it remains the same. India and China remain at December 1, 2020 and 2015. And the other countries remain current, and the set-aside categories, so that is the categories where the businesses are in rural and high unemployment and in infrastructure, they continue to remain current. So you see the visa bulletin, to summarize, the EB1 has moved forward significantly for India. EB2 and EB3 have a slight forward movement for India and China. And for EB3, all other countries have actually retrogressed. And for EB3 August, we can expect further retrogression. So that's about the visa bulletin. Now let's go to the next slide. So now let's talk about the RFEs, and we'll break it down a little bit for you. We'll take real life examples. And these are the topics that we're going to be talking about: maintenance of status, if your work location changes, the requirement to file a H-1B amendment, which companies H-1B dependent, what kind of LCAs you can expect in this area, and what is H-1B dependent, and how do we file petitions for H-1B dependent employers. Specialty occupation, what is a specialty occupation? What kind of RFEs? The specialty occupation RFEs are the most common RFEs that we receive. So this is extremely important to understand what is a specialty occupation, because that's the very basis on which a H1 is filed. Unless the position is a specialty occupation, you will not be able to file a H1. Numerical limitation is if someone is cap exempt, an employer is cap exempt, how are they cap exempt, on what basis? And if you say you're cap exempt, what RFEs you can expect, and what documentations to submit to avoid those kind of RFEs. Another very common RFE is an RFE for beneficiaries qualifications, requesting for an evaluation to be done, especially if there's a foreign degree. Sometimes if you have a straightforward computer science degree, even though it's from India or some other country, we don't usually put an evaluation, because USCIS kind of understands these degrees, because so many of them have been filed in the past, and they know that they qualify as an equivalent of a US degree, but sometimes they don't. They don't understand the degree. They want to see an evaluation, sometimes of all foreign degrees. So in some years, they send a lot of RFEs for foreign degree evaluation. So we get a lot of RFEs on that basis. So that's something we'll discuss. Number 6 is viable businesses. usually, especially for consulting company type situations where you don't have an MSA or PO or the person is working out of your office, and USCIS is not clear as to what they'll be working on or what kind of organization you have, or if you have a large enough organization to accommodate, to be able to pay the salary of that particular individual, then they'll send you an RFE on the viability of your business, whether you have an office space, whether what your tax returns look like, et cetera, et cetera. So let's get into each one. Next slide. The first one would be for maintenance of status. Now, this RFE will show you exactly what you shouldn't do in a change in work location. So this was a client who came to us after the RFE was the H1 was filed on their own, and they came to us and they got the RFE. And this is a learning moment as to what not to do, whether you're a beneficiary or whether you're an employer, what you shouldn't do. And you can see what happens. So in this particular case, just to give you some background, the petition was filed for this beneficiary in 2021. And when this petition was filed, the USCIS noticed that the LCA location was Alabama, but the pay stubs and the work location seemed to be North Carolina because all the taxes were being filed from North Carolina. The pay stubs, his address was given as North Carolina in the I-129 petition. So they immediately sent an RFE in 2021, stating that it seems like you are not working at the location that you're supposed to be working at. This, I guess, in 2021 was an extension was filed at that time, or an amendment was filed, whatever it was. They said that you previously you didn't seem like you were working where you're supposed to be working. So they sent a big RFE asking for W-2s, etc., etc. So what had happened at that time is that the employer basically did not notice that the address had changed. So the person was working from the correct address. He was working from Alabama, but the employer forgot to change that in their taxes. So they continued to pay taxes for North Carolina. They continued to use his North Carolina, which was his old address, while paying his taxes, etc., etc. Everything was North Carolina, even though physically he was located in Alabama. So this was more a tax violation. They didn't actually violate immigration law. So it was important to show that the physical location was Alabama as per the LCA, but it was just a tax violation, a, a tax problem. So unfortunately, the attorney at that time did not show that, did not highlight that, and therefore this case was denied. And the second mistake that the employer made was after the H1 was denied, the beneficiary continued working on his old H1 as if nothing had happened. So that was an issue as well. So that issue is also raised in this RFE. And then the third issue is when they filed this present case, what had happened is the person started working in Colorado, but they filed the petition after he moved to Colorado. They should have filed the petition before. So they brought that up also as an issue. So let's go through the RFE. It says your petition was filed with a subsequent request to extend the beneficiary's stay. To qualify for an extension, the beneficiary must show that they're maintaining status. And then they talk about how the previous petition was filed on May 5th, 2021. And they say on May 2022, you filed a petition with receipt number to amend the previously approved petition. And then in 2022, they sent an RFE. And then it states that, Birmingham, Alabama was provided as the LCA information, but the address was mentioned as North Carolina. And then it goes on to say that furthermore, the previously filed petition and the current address, you have provided a copy of the beneficiary's 2021 W-2 from your organization. This W-2 does not show any wages paid to the beneficiary for work performed in the state of Alabama. Instead, it shows that the organization only employed the beneficiary in the state of North Carolina. This is the last paragraph. So this is what they're saying is what I just explained. Next page. Furthermore, they say you've provided a copy of the beneficiary's 2022 W-2 forms, and even this has work performed in North Carolina, and you show that the 2022 forms also have work performed in Colorado. However, you never submitted a USCIS request requesting approval for beneficiary to work in North Carolina because the person was not actually working in North Carolina, he was working in Alabama. But the taxes all show that he's working in North Carolina, right? So they say that they denied the petition in 2022. They denied your request to extend the beneficiary status. You were informed that since you did not file a petition to reflect a change in beneficiary's employment, the beneficiary has not maintained their previously approved H-1 status. And it says that at this time, you are further informed that the decision may leave the beneficiary without any lawful status, etc., etc. So now at the time of the denial, the beneficiary was required to obtain a valid visa and leave the country and come back into the United States. So that's what they're saying, but they're saying that the records don't show that anybody has left. The record shows that the person is still in the US, so they want to know what's happening, on what basis they've been working since 2022. This is now 2024. Therefore, it appears the last paragraph, the beneficiary has not maintained their non-immigrant status as explained and detailed above, right? This is all that they're saying. Next page. So now they're asking for all this information, detailed explanation regarding change in work location, copy of the approval to show that that new work location was actually approved by USCIS, any receipt numbers for the petitions that you might have filed asking for a change in work location, all your payroll documents, work schedules for the prior years, quarterly wage statement showing where the person worked, the federal tax returns, work product information, performance reviews, everything. They're asking for employment history records, copies of a valid visa to show that you left and re-entered the country. They're asking for all this information, and of course they have nothing, or even if they have any of the documents, it's not going to be in their favor because there was a mistake, and they just continued working on the previous H-1 instead of leaving and coming back after filing a new H-1 and correcting all the mistakes. So based on all this, what we did was we tried to respond in the best way we could. We showed them that with reference to the address issue, that even though they say North Carolina in all the taxes, the person actually did work out of Alabama, and we showed proof of physical presence in Alabama. We showed his copy of his lease. We showed all his utility bills. We showed his credit card statements, his bank records to show that he actually was living in Alabama, right? So that's how we sought to take care of that issue. With reference to the fact that he never left the country after getting a denial, we said that he worked based on his previous H-1B petition because the previous H-1B petition was never revoked. So he did not actually have to leave the country. And we argued it that way, that he had previously an I-94 and he worked based on that. So at least there's no accruance of unlawful presence, which is important. There was an I-94, even though he's not maintained status technically because they never actually explained the fact that he worked physically in the correct location, so he didn't maintain status. But there's no unlawful presence because there's an I-94, so that was important to show them. And the third thing with reference to Colorado is we said that, yes, he did move before the USCIS petition was filed, but it was only 30 days since he moved. And that's how, and there is an exception with reference to the law that you can move within 30 days of, and then you can file an amendment 30 days later. Having said all that, they did send a denial, and though they accepted a few things that we have said, on the whole, the obviously the beneficiary did not maintain status, did not explain properly with reference to what had actually happened, and by the time we explained, it was too late. So they denied the entire petition, and now the beneficiary left the country and is hoping to refile. And we're hoping there's no unlawful presence issue here because there was an I-94 based on which he worked, even though he shouldn't have, because after that he moved to different locations and he still worked on the previous, LCA petition. So that's how we dealt with it. And you can see the mess that it's created. And we were not able to correct the mess that happened 2 years ago. And, the person had to basically leave. So this is an example of what not to do. So if you're a beneficiary, make sure, that is, if you're an employee, make sure every time you move your location, inform your employer. Not only inform your employer, if it is outside of the outside of the different, if it's a different county, then tell your employer to file an amendment, right? So if it is outside of commuting distance, if it's within commuting distance, then that's fine. But if it's outside of that, you have to tell your employer to file an amendment. Otherwise, you will fall out of status, right? So a very important takeaway from this RFE. Next. Yeah, H-1B dependent. Now, with reference to an employer, whether they are H-1B dependent or not, a person who is H-1B dependent is, this is how they define it. A H-1B dependent employer is defined as an employer that has 25 or fewer full-time employees, and 7 out of that are on H-1. So if you have less than 25 or less than that, 7 of them are on H-1, then you are on H-1B dependent. If you have 26 or more full-time employees, then if more than 12 are on a H1, then you're dependent. If you have 51 or more full-time employees and at least 15% of them are on H1, then you are dependent. So if any of these apply to you, then you have to mention in your LCA specifically that you are H1B dependent, and you have to attest to the fact that you have followed some of the rules with reference to H1B dependent employers. So there's a special tick mark that you have to do for H1B dependent employers. Now, in this particular case, there was only one employee, and we said that the person was not H1B dependent. But the USCIS is saying you have not established, this is the last paragraph, that you are not H1B dependent employer. You indicated on your I-129 petition, page 19, that you're not H-1B dependent. Likewise, you indicated on page 6 on your LCA that you are not H-1B dependent. However, petitioner indicated on their I-129 petition that they have a total of 3 employees. USCIS records, however, indicates that the petitioner has filed 5 petitions within the last 1 year, of which 4 have been employed. So they're questioning whether you have 3 employees or you have more. So they're questioning how many employees you have, because they're saying that we have approved 5 petitions. So how is it that you have only 3 employees? So they are questioning the whole, 3 employees thing. They're thinking that maybe you have more. The reason this is important is because if an LCA is filed as a H-1B not dependent and you are dependent, then the entire H-1B can be denied, because you cannot then go back and file a new LCA, because there has to be an LCA that is filed as of the date of filing the H-1. So this is what they're trying to look for. They're always finding ways of denying the petition, and this is one way that they look into to see whether your case can be denied. So in order to avoid these kind of an RFEs, you should preempt it by maybe submitting your payroll record to show how many employees you have as supplementary evidence in a petition. Next slide. So they're asking for evidence to show that you either a new LCA if you are H-1B dependent, which is not possible to do, right? Because we can't go backdate an LCA unless we already have an LCA that maybe we filed for someone else. This would not have been an option. The only option is to show that we are not dependent, and these are a few documents that they're asking for. Statement that explains how many employees you've employed at the time that this petition was filed. So how many employees do you have? The 941 quarterly federal tax returns for the last 2 quarters just before you file this petition and that will show the number of employees that you have. Quarterly wage reports for all the employees in all the states. This will also show how many employees you have. And then they want a table to show how many employees you have and how many of them are on H1 so that they can see whether you're dependent or not. So this is documentation that can be submitted ahead of time when you're filing your H-1B petition, especially sometimes when it's very close, the number of employees, and this can be for various reasons. It can be cap exempt reason because you can't past that 7 employees or that 25 employees, or it can be for the reasons of the filing fee. Though not discussed in this RFE, if you have less than 25 employees and you pay a certain filing fee, but say you have 24 employees, they'll definitely send a similar RFE asking for proof of the number of employees that you have. So you're better off submitting these kind of documents, quarterly federal tax returns, etc., to preempt that kind of an RFE, especially if the number of employees that you have is close to that number where you have to pay the additional fee. Next slide. Specialty occupation is another big RFE volume of RFEs that we receive is specialty occupation. And we usually know for which cases we will get an RFE, and sometimes there is an RFE for a particular reason. Usually if we file a developer position, we don't get an RFE. This particular position that you see is for a data analyst or I believe it's a data engineer, senior data engineer position, and there is an RFE. They're saying in the RFE that they're talking about what a specialty occupation is. You must establish that the beneficiary's profit position is a specialty occupation. An occupation is one that requires a theoretical and practical application of a body of highly specialized knowledge and that requires attainment of a bachelor's degree or a higher in a specific field, specific specialty or its equivalent. They're saying that we submitted a petitioner letter, we submitted an LCA, but that's not sufficient to show that the position is a specialty occupation. They're saying that you indicate that the minimum entry requirements for the position is a bachelor's degree in mathematics, statistics, or computer science, or a related field. But they're saying that there's no proof that there's correlation between these fields. So it has to be a specific specialty. It can't be various different fields, right? So it has to be a specific field, or various fields that are closely related. So they're questioning how math, stats, and computer science are related. So unless you're able to show that each field is specifically related, this may not be a specialty occupation. So we basically submitted a response showing how these fields are quantitative fields and how they're related and how a lot of the subjects taken in these various fields are similar by showing all the transcripts in various fields. Next slide. So that was one part of the RFE as to how are all these different fields related. And then they also show that they want us to show how the field that we're mentioning is related to the duties or responsibilities, right? And they're saying USCIS does not use a particular job title, but when determining whether it's a specialty occupation, but they actually use the job description. And they're saying that the job description that you are given is very broad because you are using the word should be able to design, develop, should be able to create. So it looks like it's a very broad just description and doesn't actually talk about what the person will actually do. So in relation to this, and so they said that since we don't know what the actual job description is, we don't know whether the job description requires a bachelor's degree in computer science or not. So in response to this, we submitted a specific job description. We submitted a percentage uh, of time that they'll spend on each job, and we submitted an example of each job. So say we said the person will be designing and developing applications and reports according to business requirements. So we give an example of what kind of you know designing and development they did, what kind of reports that were prepared. We give a copy of the report, copy of the work, and we give example of their day-to-day activity under this broad job description. So that's how we took care of that. Next slide. And also it says here that they want to know how the degree is related. So now they talked about the job description. They talked about how the various fields are related to each other. And now they're talking about how is the degree, the bachelor's degree in chemical engineering and master's in business analytics is related to a data engineer position. So we basically created a table for job description on one side and his master's in business analytics, the subjects that he took, and we show how they were correlated. In addition to that, we also submitted expert opinion evaluation from a professor who again explained how the degree is related and how the position is a specialty occupation, why the job duties require a person to have a bachelor's degree in computer science or related or business analytics or related. So those are the few things that we did to explain, um, the uh, explain the complexity of the job. With reference to the complexity of the job, we also said that a bachelor's degree is required because the job is so complex. So we explained how it's complex, and we explained what are the complexities in this particular job. So these are some of the ways how you would respond to a specialty occupation RFE. But if you don't want to get a specialty occupation RFE, number one, make sure you choose a position that the USCIS is very familiar with and where it's very easy to show that a bachelor's degree is required. Usually you would go to the Occupational Outlook Handbook, which is a Labor Department book, which is available on the um, on Google on online. It's called OOH, Occupational Outlook Handbook, and each of these this book has lists all these different positions, and it says what is the criteria for each position. So if it says in that particular book that a bachelor's degree in computer science is required, then you're most probably okay to file the H1 for that particular position. If it says it's not required, then you'll have an uphill task. You'll get an RFE such as this, where you'll have to then explain why your particular position requires a bachelor's degree. Another thing to do, which we should have done in this case, was describe the job duties more specifically rather than giving broad job duties. Usually we put in the job duties that the employer gives us. In this case, the employer gave us a broad description, and we should have reached out to the employer for a more detailed description. So that's what should also be done, right? Next slide. So next, I want to talk about the numerical limitation RFE that we get. Now, this is if you're CAP exempt, and I think we won't dwell on this too much because we're running out of time, and I want to give some time for questions as well. With reference to whether your employer is CAP exempt, they can be CAP exempt in many ways, and there's a list of the different ways that you can be CAP exempt here. Can you zoom in a little bit? If it's
Unfortunately,
possible?
I won't
No,
be
you
able
can't.
to.
Okay. Okay. So hopefully you can read it. or if you need glasses like I do, please wear your glasses to read it. But yeah, so if you're an institution of higher education, oh, you actually did it.
Yeah, I was able
But
to.
a little too much though. Maybe go back to the previous one.
Okay.
So if you're an institution of higher education, if you're a nonprofit entity related or affiliated to an institution of higher education, if you're a research organization, you're a government research organization, or say you are a consulting company and the client actually qualifies as a CAP exempt organization, as one of these above organizations, then also you can file your H-1B petition even after the CAP is over. Um, so there are various other, if you have counted towards the CAP before, um, or if you are on a J1, you could be CAP exempt if you're a doctor on a J1 and you've received um, a J1 waiver. Also, if you're an employer subject to Guam Commonwealth, so if you're from there, then that could be also CAP exempt. If you're subject to the Guam Commonwealth of North Marine Islands, CNMI. If you have a company there, then you could be CAP exempt as well. So they're saying that you have filed for a CAP exempt, and obviously the registrations are closed for this year, but we're not convinced that you're actually CAP exempt. And in this case, it's a little complicated because this is a nurse case and a consulting company is filing for a nurse. So the end client is CAP exempt because they are a hospital, but they are CAP exempt because they are an higher education, an institution, a non-profit organization related to an institution of higher education. So they are a hospital and they are related to the University of North Carolina. So they are related to educational institution, a higher education institution. So it was a multi-prong RFE where we had to prove many things. Go to the next slide. So they're basically saying that you did not submit documentation regarding this issue. Please submit evidence to show that you qualify as a nonprofit entity related or affiliated with an institution of higher education. I'm reading the last paragraph. Evidence may include but is not related to the following. Next slide. So these are the documentary evidence that they're asking for, documentation showing that you are connected to, associated with an institution of higher education. Usually there's a contract to show that, the hospital is connected to a college. But you also have to show that, so we did submit the contract, but they want to make sure that not only is there a relationship, but the beneficiary will be employed in a role which furthers that relationship. So if this hospital is a teaching hospital, then the beneficiary as a nurse should be teaching other nurses that are going to school, right? So they want to see a correlation there also. So there's a lot of information to be provided in this case. At the nexus between the job and the what the organization actually does, the contract between the hospital and the organization, uh, proof to show that it's a nonprofit organization. So a lot of documentation has to be submitted. So obviously, if this is a teaching moment, because you can see how much documentation has to be submitted for a CAP exempt organization. So submitting this ahead of time will help avoid these kind of RFEs. Next slide. And also teaches you as to what documents is needed for these kind of RFEs, right? So they're saying that in order to show that it's CAP exempt, look at the last few bulletin points. Detailed itinerary showing the number of hours the beneficiary will work at the organization, submit a letter from the organization that confirms the working hours. So they want to make sure that they're not going to be working at the consulting company, but the entire period of time they'll be working at this qualifying organization. Explanation and evidence regarding the nexus between the beneficiary's job and the essential mission, purpose, or objective of the qualifying organization, which is basically supporting the institution of higher education. Then contracts and work orders to show that there's a relationship between the hospital and the teaching institution, evidence that the work location is, a non-profit, right? That's one of the, so then the way to show that is, showing their tax exempt status. So a tax return should be sufficient. So this is some of the information needed in this situation. Next slide. Another kind of common RFE that we get is um, beneficiary qualifications. As I was mentioning earlier when we were talking about specialty occupation, when the person has a foreign degree, they want to either they want either a copy of the US degree, or if it's a foreign degree, they want the second bulletin point, hold a foreign degree determining to be equivalent to a US bachelor's degree required by specialty occupation from an accredited college or university. So they want an evaluation showing that the person has the equivalent of a US degree and that the degree is related to the job that they're going to be working in. Um, or they have a license, or if they don't have a degree that's related, then you can show that they have work experience. So go to the next slide. If they don't have a degree that's related, then perhaps you can show that the person has, um, work experience that is equivalent to the degree, right? So an work experience evaluation then can be submitted, and the work experience evaluation must show that the person has 3 years of um, work experience, which is equivalent to 1 year of degree. That's what it says here in this page. Next. And usually an evaluator will show that the 3 years of work experience is equivalent to 1 year of degree. You can go to the next page. Sometimes USCIS will also determine equivalency for you if you don't want to go to an expert opinion letter. Then you have to submit all the documentation, the 3 years of work experience. You have to show that the 3 years was progressive work experience. You have to show what degree you have, and you have to then have USCIS determine whether it's equivalent to a bachelor's degree in, say, computer science or not. Next slide. So this is a pretty common kind of RFE that we get. And in this kind of evaluation, if there is an expert opinion evaluation, if you read the last few bullet points, they're asking for the professor's qualifications, the person who's giving the evaluation, they're asking for their qualifications. So you have to submit their resume, you have to submit, if they are giving you an expert opinion letter on a work experience, then you have to submit a letter from the university stating that they qualify, and they do this for the university on a regular basis, meaning that they qualify their students' degrees and they for work experience. So if they do this on a regular basis for the college, then it should be fine if they're giving an expert opinion letter for USCIS. So you have to get that letter from the college saying that they do that on a regular basis for the college. And so we submit a detailed resume of the evaluator also showing how they're qualified to give this kind of evaluation. Usually if we're trying to evaluate a computer science degree, we get a professor in computer science. Next slide. This is the last slide. We have to show that the business is viable. Usually, if it's a consulting company or even otherwise, if you're not able to show that you if you have not submitted documentation to show that why you're required to hire this person, so if you don't submit the MSAs, POs, and work orders, etc., then in that situation, usually they will ask for, you know, this kind of this kind of an RFE where you have to submit proof that you are actually a viable business and you're doing sufficient work to show the that you have a job for this person. So just quickly looking at these bulletin points, they're asking for the W-2s of all the employees. And when you're submitting these documents, you're not just submitting the documents blindly. You have to make sure that you vet the documents before submitting them, because if you're submitting W-2s and if they see in the W-2 that someone is on a H-1 and they're not being paid the prevailing wage, then that could lead to RFEs or denials on other cases, or a notice of intent to deny on a case that was already approved. So your tax returns, the organizational chart showing where the person will sit within the organization, a lease of the office. They want to know where the employee is going to work. So they want to know that you have a physical premises. They want to know what kind of a premises it is. Is it an office premises? Is it a workhouse? Is it a manufacturing premises? They want the floor plan. They want photographs of the office. They want utility bills to show that you're actually working at that office. So this is that all we have? Next slide. That's it. So we can open. Yeah, so this is, I hope you have, I think it's a very, very detailed overview of what kind of RFEs to expect, and it's almost to the level of being able to file your own H-1B petition if you need to, and responding to your own RFE without an attorney if you need to, or at least having an idea as to what to expect from the attorney, or whether if the attorney prepares a response, you'll actually be able to look at it, because that's the level of knowledge that you have now. We can go to the Q&As if there are any.
So I'll take the first question, and Prashanthi, I apologize in advance for my limited audio today.
No problem.
We are a first-time H-1B CAP filing company. We file the H-1B case, but doesn't include any doc related to business. So will it cause any problem? Start up using it.
Okay, can you just read the question again? So sorry.
Sure, yeah,
Is
no
it
problem.
Yeah, sorry.
Yeah, it's the very first one we got. We are first-time H-1B CAP filing company. We filed the H-1B case, but didn't include any docs related to business. Will it cause any problem?
So it's difficult to say whether it will cause a problem or not. The worst case scenario is that you might get an RFE. If you do get an RFE, then I've just told you how you should respond to those RFEs. You can always submit the documentation in response to a request for further evidence. But in general, when you're submitting your next H1, it's always good to include some business-related documentation with your H1.
All right, that answers that. And Prashanthi, these questions for your information, they have come into the Q&A session and not the chat window. Yeah.
Okay.
My I-129 receipt issued mentions Nebraska Service Center, and the case is actively being reviewed. Is Nebraska Center is correct, and what will be next action on this?
Well, that shouldn't be a concern. That's up to them as to where they process the case. So sometimes even if you send it to one address, they might process it at a different address. It is very important though to, I mean, obviously if they've accepted it, that means it's correct, because if it is not the correct address, then they would have returned the package. But having said that, very, very important to look into the address issue carefully, because it is not straightforward. They've made it very complicated as to where to send, petitions. and they've changed everything since August 1st. So I would just be careful and cross-check, double-check, triple-check before sending out any H1. Make sure that you have the right address because they've changed it from last year, and their instructions also are not very clear. So that's why I triple-check. But if you've sent it, you've gotten a receipt, you should be okay with reference to the to the address. The next action would either be an approval or a request for further evidence. So you just have to wait and see.
Noted. Next up is, so when you say education and relevant work has to be related, then if a person has done civil engineering, but working in computer programming, will that be a challenge?
Yes. If you are only submitting your civil engineering degree and you're submitting a H1 as a computer programmer or a developer, it will not be approved. So you need to do something more here. So if you're in the civil engineering, if you have a civil engineering degree, but you have work experience in IT as a computer programmer or some other IT related position, then you need to you need to submit an experience letter for at least 3 years. The experience letter has to have a detailed job description, and it has to show a start date and end date, and it has to be 3 years or more. In addition to that, you have to get a work experience evaluation submitted along with your H-1B petition. Otherwise, you will get an RFE for sure. So something to keep in mind, the work experience evaluation has to be done properly. It has to be done by a professor who can submit a letter from his school, from his college, saying that he qualifies to give such a work experience evaluation. And of course, he has to be qualified because if it's computer science, then he has to be a computer science professor, not a professor in business, right? So all these criteria have to be met, and then your H1 will get approved.
All right. Next one is, when we made education evaluation for a mechanical background, as it is important to us to also request an experience evaluation for software developer position.
When you say when we made educational evaluation for mechanical background, is it important to use for us to also request experience evaluation for software developer? I didn't quite understand the question, but looks like no. I mean, depends on what the position is, right, Sarat? So if the position is that of a mechanical engineer, then your educational evaluation for a mechanical engineering degree is relevant. But if you are filing your H1 for a software developer position, then your educational evaluation, it's useless to submit an educational evaluation which says that you have a bachelor's in mechanical engineering because it's not relevant. Then you need a work experience evaluation showing that you have the equivalent of a bachelor's degree in computer science based on the mechanical engineering degree and your 3-year work experience letter. They can equate both of them to be equivalent to a bachelor's degree in computer science. So yes, I hope that answers your question.
Great. We have about 5 minutes left to end this webinar. So if you have any questions, now is the time. You can use the chat window to ask. Prashanthi, the next question is, my H-1B got approved last year, and I have applied multiple H-1s through different companies. I asked this question last year, and you suggested me to wait until March 24, brackets, since there were some cases and work around going on with USCIS. So my question is, I am planning for an H-1B stamping. Can I know if I can get it stamping this year, or there are any good chances it will be approved?
So I'm just going to, repeat the question again, at least the relevant parts for those listening. He says that he applied for a H1 through multiple companies last year. I'm planning for H-1B stamping. Can I get it stamped this year? Okay, so you filed the H-1 last year. You did it through multiple companies. You were worried last year that if you filed it, since you did it through multiple companies, whether there would be any issue at the consulate. I might have asked you to wait and see how things pan out. As of now, this is a non-issue because they have removed that whole multiple filing incentive from the registration process itself. So that is not in the eyes of USCIS an issue anymore. I'm not sure at the consulates if they are treating that as an issue or not. Um, it should not be. I mean, anyway, bottom line is you have not done anything wrong because you are allowed to file multiple H1s. The companies are not allowed to file multiple H1s through their, related companies, but you are allowed to file as long as each company had a separate job offer. So I would say, rather than wait any further, go for a visa, go to the consulate, because unless you go for it, how will you know?
Great. I have another one. For software developer position, should we have to request education and experience evaluation if the consultant is with mechanical foreign bachelor's?
Yes, you do have to.
That was
Absolutely. That's what I just
one.
said in the previous one. Yeah, you do have to.
Okay. I got another one. I'm reading that through. I think it's a continuation of one of the previous questions, Prashanthi, and this one is in Q&A session. So this is not about H-1B, but L1A, if okay, a person employed on L1A as a manager being promoted to an executive level, the documents required for filing will differ. Will this change hamper as the person turned executive doesn't have or anyone reporting to him?
Right. So the question that they're asking, Narendra is asking, is that it's an L1A person employed as a manager, but they're being promoted to an executive. Um, yeah, this is a little tricky because you file your L1 as a manager previously. Now, when you're filing your extension, you can certainly file it as an executive, and the documents, yes, are different in an executive position when compared to a manager position. Uh, so will this hamper or have any problem as the person turned executive doesn't have anyone reporting to him? Now you have to remember, even as an executive, you have to have people reporting to you. Just because you're an executive doesn't mean that there are no people. I mean, most executives will have people reporting to them because they are top level employees. So if it's not just a manager level that has people reporting to them, it's executives as well, right? So it's going to be difficult maybe then for you to prove that you're qualify for an L1A in an executive position if there's nobody reporting to you. So I would be careful about that. It's going to be an uphill task to show that you're still working in an executive position by showing that you're doing other things, but you're in a top level position and no one is reporting to you. Then you have to put in an additional effort to show that you still qualify as an executive and you meet all the other requirements except for this one. Good luck with that.
Thank you. And on that note, Prashanthi, it's a wrap for today. Thank you once again for your time. And yeah, we look forward to seeing you in the next webinar. So yeah, on that note, we'll wrap up today's session. And once again, thank you so very much for attending this webinar.
Don't forget to subscribe to our videos if you like what you see. Also give us a thumbs up and share the video with your family and friends. Thank you.